back on record. Mr. Bacala, you're up at the podium. You have something to say?
Your Honor, I didn't go hunt down a printer over lunch. We just had lunch and talked about our summations. So I've got just what the prosecution provided, 3 additional blog posts that I'd like to amend.
Go ahead. That's exhibit.
Not sure. Whatever the Alaska blog is.
Day 10 should be in there.
Day 10, Day 11, and Winter Protest. That's what I've got.
Q? Was it Q?
B-R.
R.
R.
Okay.
So, thank you.
And I understand from my in-court that there are no objections to the jury instructions then? Is that correct?
Your Honor, we don't have anything that we want to amend to the jury instructions. We're really relying on the fact that you have stated that these are standard.
These are what we refer to as boilerplate, and they seem to be normal instructions. A lot of the jury instructions, to keep an open mind, all that stuff is all standard stuff. The main thing is the trespass and the affirmative defense, which seems to state the law correctly. So, we have the jurors all here. We told them 1 o'clock. We're ready to proceed?
Ready.
Okay, let's bring them in.
My understanding, prosecution goes first with their closing argument.
Prosecution will go first, then defense goes 1, 2, 3 again, if you want to keep that same order, and then prosecution gets a chance to rebut the case, or rebut the arguments, I should say, and then I get the chance to charge the jury. I may break in between, just depending upon how long everything goes, but that's the order in which it will go.
Hello, John.
Please be seated. Okay, we're ready with opening statements. The prosecution, because it has the burden of proof, gets to go first. Then after that, the defendants will be given an opportunity to argue the case to you, and then once they're done, the prosecution has a chance to rebut the argument. Once that's all done, I will then give you the instructions concerning the law, which I'm putting into final form right now, and then we will begin deliberation, maybe. We'll see how long this takes. So, with that, Mr. Berger, are you going to be opening up?
I'm not. I'm going to be assisting
Ms. Pratt?
colleague in setting up the easel.
Okay.
We have an opportunity, Your Honor, to view what is being, since it's being faced away from us, so they could give us some perspective on what they're...
Is there a way to turn that once you get that set?
No. you. May it please the court. Mr. Martin, Ms. Thompson, Mr. Bakala, ladies and gentlemen of the jury, thank you for your careful attention during this trial. I'm going to go through the elements that are the law that the judge is going to give you. And if you recall, we talked at the beginning about the judge gives you the law and then you decide the facts and how they apply to the law. And since this is a kind of a bifurcated trial, there's two parts to it. We're just going to go pretty quickly through the first part of it, which is the municipality's burden of proof. So, as I told you at the beginning, I have the burden to prove to you beyond a reasonable doubt that each individual defendant violated this ordinance, trespass 845-010-A3 in the municipal code. And that is that on or about May 17th in Anchorage, Alaska, the defendants knowingly entered or remained on public property when it was not then open to the public or when they had been asked to leave by someone with apparent authority to do so. So when you look at the evidence in the case, and you think about the witnesses that we brought to testify, and you think about the video, what you saw was these three individuals, Mr. Martin, Ms. Thompson, Mr. Bakala. You saw them at various times on the tape enter the park, Town Square Park. We know the park was posted with public hours, that it was closed at 11 p.m. We know from the evidence that both Mr. Rada and potentially some police officers had cautioned all of the defendants on previous occasions that the park closed at 11 p.m. and they weren't able to be there. And we know that they remained there after the police asked them to do so. We saw that on the video. So when you look individually at each defendant and you look at did I, as the representative of the municipality, prove to you that on or about May 17th, John Martin in Anchorage, Alaska was on public property? Yes. I don't think that there's any dispute as to that. Was Mr. Martin remaining in the park after it was not open to the public? Yes. There's no dispute about, oh no, it was 10:45, we were going, anything like that. Was he asked to leave? You saw it on the video. Yes, he was. And did he know the park was closed? Did he know he was being asked to leave? Yes. So, there you go. John Martin, guilty of trespass at this point in time. Now let's talk about Margie Thompson. Was she on public property? Yes, we saw her come out of that bush and sit down, lean to with Mr. Martin. Saw that on the video and heard the officers testify about that. Did she understand the park wasn't open? Well, they told her on the video. And she testified, and there was nothing about any of the testimony in the trial that would indicate that she did not understand the park was closed at 11 p.m. Was she asked to leave? Yes, she was. In fact, if you remember, the officer said, we'll give you 15, 20 minutes to gather your stuff, we'll help you gather your stuff, we'll give you a ride, we'll take you wherever you need to go. Did she know that the park closed at 11 p.m.? Yes, I think there's ample evidence from the video, from the testimony, that she knew. And finally, with regards to Mr. Bakala, was he there? Yes, we saw him enter the park. We heard his testimony. He wasn't in the park at 11 p.m. He wasn't trespassing in the park when the police arrived. But he came into the park from his beer run, and he insisted on staying. So, did he know the park was not open to the public? Yes. The overwhelming evidence is he knew that, and that he was asked to leave, and that he was very familiar with the law. In fact, had made a pledge both to John Rada, the Director of Parks and Recreation, and on his blog discussed, you know, the park closes at 11, it opens at 6. Why fight that fight? Why not just follow the rules, get out, and then go back in when the park is open? So when you look at that, that's it. That's our case. Municipality proved beyond a reasonable doubt that each of those individuals committed the offense of trespass on that date. Now, the individuals indicated to you, the defendants indicated to you in opening statement, they indicated to you in jury selection, and they indicated to you in their case that they were attempting to raise and prove this affirmative defense. It's really important to remember, and you'll be instructed in the jury instructions, that that is not on me, okay? That is not a burden that I have to disprove. you are not permitted to go back in the jury room and say, well, Cindy Franklin didn't disprove that they were trespassing. That burden shifts, and the burden is on them. It's a different burden of proof than I have. I have a burden of proof beyond a reasonable doubt. They have a burden of proof by a preponderance of the evidence, and you'll get the instruction in the jury instructions that the judge is going to give you what that burden is. It's more likely than not. It's an easy burden. Is it more likely than not that they met each of these elements of the affirmative defense? So, I want to talk about unanimity, because there are 6 of you, and your verdict in a criminal case has to be unanimous. That means that if we were just talking about the trespass part, all 6 of you need to agree that the municipality proved to you beyond a reasonable doubt that the defendants were trespassing in the park. And if you decide in the end that the defendants met the affirmative defense, such as to be entitled to a not guilty verdict, then you have to agree on that unanimously. But there is no requirement of unanimity in these individual elements. For instance, suppose you go back and 3 of you say, well, I don't think they were protesting at all. And the other 3 say, oh yes, they were protesting, but I don't think it was a reasonable time, place, and manner. All you have to decide is whether or not, as to each individual defendant, did each individual defendant meet their burden of proof and prove to you that they were essentially entitled to break the law. Because that's what it comes down to, right? We broke the law, but under these circumstances, we're allowed to. You have to let us break the law, and this is why. That's why it's their burden, because they're basically saying this law doesn't apply to us. It applies to all of you. If you were out in the park, you're not allowed to be there, but we are. We're special. We're entitled to break this law, and we've proved to you that we are because of our actions. So that's why it's each individual defendant. As they get up and talk to you, I want you to hold them to that. Don't let Margie piggyback onto John. It's not John's responsibility to prove Margie's affirmative defense. Okay? Miss Thompson broke the law. I proved that to you. Miss Thompson has to prove to you by her burden of proof that she was entitled to break the law. Same with Mr. Bacala, same with Mr. Martin. So you should be looking in each of them for these elements. Did Mr. Martin prove to you that if you look at the instructions, at the time of the trespass, at the time of the trespass, he was engaged. Think about that word. He was engaged in legitimate expression. When you're expressing something, you're communicating it. What was he engaged in? What was he communicating? What message would anyone have received? This is why we spend a lot of time on this, because this is his burden to prove that at the time of the trespass, he was engaged in the legitimate expression of First Amendment freedoms. That's just the first prong of the affirmative defense. Why is it so hard? It's hard because what you're saying is, I am entitled to break the law. That's why it's hard. We write these laws so that they apply equally to everyone, right? So when an individual comes up and says, under these circumstances, I am entitled to break this law doesn't apply to me, then the law doesn't make it easy. It's hard, on purpose, because the laws are designed to apply to everyone equally. So that's your first question with regard to John Martin. Did he prove to you, by his evidence or by our evidence, that at the time of the trespass, he was engaged in the legitimate expression of his First Amendment freedoms? I submit to you he didn't prove that. But I'm leaving it as red circles because you need to hear their argument, and you need to hear about why this is what you're looking for, right? Prove to me, Mr. Martin. It's not Ms. Franklin's burden to disprove it. It's Mr. Martin's burden to prove it. And then, if you get to the second prong, possible you might not. Possible you might say, you know what? Sitting under a tarp drinking beer is not engaging in the legitimate expression of First Amendment freedoms. Cheers, mate, right? But if you say, yeah, sure, sitting under a tarp, drinking beer, because you're John Martin, and because you're always engaged, you know, you're engaged in that, then you get to this second prong. And the second prong is that John Martin proves to you, regarding his conduct, that when he was doing that, sitting under a tarp, drinking beer in the park after it was closed, that he was not expressing himself in a manner that was an unreasonable time, in conduct that was an unreasonable time, place, or manner. I don't think you got there. Because the reason we have rules for the park is so that we have the ability to close the parks at night. I want you to remember, and it's very important, for you not to get caught up in some of this straying off down the path of the federal Constitution. You're not going to get any law about the federal Constitution. Judge Motico is going to give you the municipal law, because those questions have been settled and answered, and they're not for you. Whether or not can the municipality write this law, that's not something you need to worry about. What you need to focus in on is, did John Martin show me that he was engaged in a legitimate expression of his First Amendment freedoms, and that even if he was, that he was not doing that in an unreasonable time, place, or manner. And then you go and you look at Ms. Thompson and you ask the same questions. What was she engaged in at the time of the trespass? Was that a legitimate expression of her First Amendment freedoms? And was it something that was not in an unreasonable time, place, or manner? We offered a lot of evidence in the trial to show you why it is reasonable for the municipality to have these limitations. And it's just important to remember that. It's a balancing act, right? Same with Mr. Bakla. At the time he was on that beer run, when the officers came into the park, was he engaged in a legitimate expression of his First Amendment freedoms? Well, he wasn't even in the park, right? He wasn't even there. He was on a beer run, he was taking a break. But when he came back, you know, you saw what he said when he came back. Hey, I've got to be here, I've got to be here, I've got to be here with John. Was that engaging in the legitimate expression of his First Amendment freedoms? And if so, if you get that far, was it not an unreasonable time, place, and manner? So that's your job there. And there's just a couple more things I'd like you to look for as you listen to the defendant's arguments. So first, look for each individual defendant to meet his or her burden of proof. Don't let any defendant slide in under any other defendant. This isn't a group effort. This isn't a group issue. You know, we proved each individual defendant broke the law. They each have the burden of proving that they were entitled to break the law, that that law did not apply to them at that time. Look for proof of their claims. They made a lot of claims to you in their opening statements. Remember, Martin said he was going to prove it was a Cynthia Franklin cover-up, that this whole thing was a Cynthia Franklin cover-up. There's been a lot of implication through the trial that the city is just trying to shut these people up. Where's the proof of that? Where's the proof of that? I submit the proof has been that the city has gone above and beyond. If I could do a back bend in court, I used to be able to, I would do it, because that's what I feel like the proof has shown, that the city has bent over backwards for these people. Mr. Rod has given his personal cell phone out to them. We've taken the time. We've tried to be as polite as possible. We've tried to give them as much freedom as possible. And really, we're just trying to protect one little line in the sand. No parks after closing. That rule applies to you just like it applies to everyone else in this city. Ms. Thompson's opening, she said she would prove how police officers decide to represent themselves. I think there was a little bit of implication there. I think she talked to you in in jury selection about this tactical deception. You know, sort of this implication that the police officers lied. Find it. Find the place in the testimony where the defendants prove the police officers lied. Don't just let them throw out these statements. These police officers are out there every day. on our behalf, doing their job. And these people just didn't come into court and throw this stuff around, this kind of career-ending implication. Cindy Franklin's involved in a cover-up. The police officers lied. And then I think you remember Mr. Bacala's opening about the magical chair. And I think at the end he said, the chair is built for people who lie. Who's lied? Make them follow up on that. You know, I mean, if they're going to throw these statements out there and say they're going to prove it, look for the proof. There is no proof of anyone lying or trying to squelch these people's message. If anything, the evidence has been the complete opposite. And finally, I'll ask you, you can just keep a little tick mark on your notepad if you want, as you go along, as you listen to them. There are a lot of choices that these people made. And there's a lot of language that they've used throughout the trial to misrepresent the choices that they've made as being someone else's fault. You know, the plan was to arrest us. Cindy Franklin ordered our arrest. Well, you found out that's not exactly true. The question was, were they going to get out of the park or not? The people who ordered their arrest were themselves. Because if they'd gotten out of the park, they would not have been arrested. They could have come back at 6 a.m. the next day and resumed their protest. You heard a lot of evidence, not evidence that the defense wanted to really bring out. They want to bring out the times when they weren't able to say what they wanted to say. But really, it should be apparent from the entirety of the evidence that for years, these people have pretty much in Anchorage said whatever they wanted to say, and for the most part have been left alone. It's really just when they cross this line in the sand, and when they cross it, it's their choice. They had choices. No one ordered their arrest. The question was, they're in the park after close, are they going to get out or not? Officer Haywood, we'll help you. We'll assist you. We'll put your stuff in our car. We'll help you gather it up. All you have to do is get out and come back when the park is open. No, no, no. So whose choice was that? Whose choice was it for John Martin to have those bruises? Are you going to hear him in closing argument taking responsibility for his own actions? Are you going to hear this clever language that he's got that sort of shifts everything? I mean, you heard him during some of his questions. Where are we supposed to go? You know, what are we supposed to do? The shifting of responsibility for their own grown-up lives onto the rest of us, so that suddenly everything that they do is our fault. Watch for that. Mark it down, because every person in this situation had choices. So after you hear from them, I'll be back just for a few closing remarks. Thank you for the inordinate amount of time and your resource spent on this trial. Appreciate it.
Mr. Martin, are we keeping the same order?
I believe we are, Your Honor.
Okay. You may proceed.
Thank you. May I handle the time?
Oh, yes, definitely.
And this may seem an unusual request, but could I sit and deliver my testimony, my closing
Go
statement?
ahead.
Thank you.
The courtroom is, if nothing else, theater.
Again, I'd like to thank all of you for the time that you've spent and the time that you've really put into this trial. I choose to sit because I've often sat in protest of the mayor's policy against the homeless. I choose to hold my sign because it's a reminder of what I'm standing for, this case stands for. You heard testimony about the events that led up to our arrest. I think by now everybody here has a general idea of what I hope to accomplish and what I've been trying to address for a couple of years. You've seen how the city has put a panel of people together to address issues of camping. You've seen the proposal that I submitted to the city. And so in that instant, I sat before a panel that answered to the mayor. In this instant, I sit before a panel that does not answer to the mayor. are free to make a decision based on your own thoughts, based on your own conviction, without the direction of the mayor to tell you what your answer is going to be. You have an opportunity to look at all the facts that we presented, to come up with an answer of how you want to address this whole trial. The law clearly laid out. It's written into the jury instructions. So in a way, it really simplifies what your duty is as a jury. It's really the answer to determine is, number one, were we protesting? Were we engaged in First Amendment activity? Certainly the evidence seems to be there, seems to be clear, and certainly there seems to be an effort by the city to pretend like we weren't protesting and to just pretend like we were just there camping, as though it was such a great place to camp that we just wanted to camp in the town square park. But you heard testimony from Mr. Rada, from some of the CAP team officers. In general, they agree. People don't camp in plain sight. When people camp, they hide out. There's a big difference. We were not in hiding. We were in plain sight, and we were in plain sight with a purpose. So I would ask that as you come to a decision, were we protesting? Yes, we were protesting. If we weren't protesting, there's a lot more convenient places to camp than right in the plain sight of Town Square Park. It brings us to the stipulation of reasonableness, or in the case of the law, the word unreasonable, as it says, that we're not unreasonable in time, place, or manner. We talked a little bit about moderation. Cynthia Franklin suggested that even a protest should be in moderation. Well, I suggest to you that this was a moderate protest. This, again, is where your personal experiences come into place. You know what a protest can be like when it's not reasonable. We see it in the newspaper all the time, especially in other countries where they don't have First Amendment rights. People go to extreme to get their point across. We took a very reasonable, very moderate approach, very peaceful approach, and very clearly from all the evidence, we didn't resist when we were arrested. We did not engage in any violence in any way. But what we did do is we made a stance in a place, in a way to bring the city to a place where they have to make a decision, so that they can't just put us off and say, well, we'll consider it, we'll think about it, we'll plan about it. In the meantime, people are dying in the streets. It's time to make a decision. Do we look out for those who are in need? Do we care that people have need? Or do we just care about what the budget's going to look like for the city? Do we just care about how we're going to make all the everything available for those who have money while we overlook those who have nothing? It's really the time to make a decision about protecting those who have nowhere else to go. You have an opportunity today. You're sitting in on my protest with me. You might not have thought you were going to be a part of a protest. You might not have realized that you were entering into a protest, but yet here you are. And now it's not the city who gets to decide if we get to continue with our protest. It's you guys. You get to decide. You get to decide if there's a reasonable purpose for our presence in the park. You get to decide if there is an outcome that is worthwhile to make a stand for. And in effect, you get to join with our protest. And in effect, you get to be the decision of whether we get to have a homeless camp or not. And I just ask you, please, don't let our efforts be in vain. Vote in favor of our homeless camp. Thank you. Thank you. Thank you, Your Honor. Thank you.
Ms. Thompson.
afternoon. I hope you're all having a great afternoon. Kind of nervous.
Can I ask, Ms. Franklin, if she's
Yes.
standing there, can you turn your microphone? I mean, you don't have to use the podium if you don't want. I was just basically saying they can put the microphone, so you'll have that microphone and that microphone, and these microphones.
Okay.
We have to keep this clear so we can record.
I know I got a kind of soft voice. I'm sorry. Good afternoon. I hope you all are doing fine this afternoon. I'm kind of nervous. I've never done this before. At the beginning of our trial, when we first walked into the courtroom, we were off record, and Cynthia made a statement that she didn't want John Martin poisoning the ears of the jury. And right there and then, I thought about it, what she said, and I said to myself, there is no way that John Martin would poison the ears of the jury, because he tells the truth, and he sat down here and told you the truth about everything. I piggyback him, he piggybacks me. That's how man and wife are. I am fully, excuse me, I fully support his efforts for the homeless camp, because I've been out there. I've seen what's happening. I've experienced it, and it's not pretty. It's ugly. They need a place to go. They need a place to survive. And, excuse me, and I was there at the protest for my children. You know, we need to lay a foundation for our children, for their rights. And they can't continue to sit down and shut up. We have to speak up for the least of the people, the homeless ones, the children, our elders, and I don't know, I'm not going to tell you how to judge it. I'm not going to tell you how to vote. I just want you to look at the facts that we presented in our case. It was peaceful, truthful, and we did not resist. And we were in active protest. And once again, I would like to thank all of you for participating and considering our protest and why we were doing it. Thank you.
Good afternoon, and thank you for your kind attention. It hasn't drug on too long, but I appreciate the week you have put into this. I'd like to thank the court and the prosecution. I think we've pretty much gotten all the facts out. I'm sure in plenty of these kinds of trials, you go back into a jury room just not really even sure what happened. I think we're pretty clear on what just physically happened. So that's good, and that's great, actually. I bet Ms. Franklin would love it if all of her cases just went like that. I think the prosecution did a pretty good job of putting on their case, and then we said we were going to do an affirmative defense, and we have done an affirmative defense. I just want to, I guess I want to go back to my opening statement. Maybe even back down from it a little bit. I mean, this is where we were at the time of my opening statement. And we've seen now from the evidence that's been presented. On May 17th, we had the clearest signs with the most political message, the freesoft.org sign, that had been taken down by an employee of the plaintiff. We had the police officers show up and testify that it was confusing. we had the prosecuting attorney's name redacted from the police report. I expected just every attempt by the prosecution to confuse and muddle this thing, and that didn't happen. And Ms. Franklin, I appreciate that very much, that you've just really given us an opportunity to present this defense. We haven't gotten everything our way, but I think there's just so much evidence before you as a jury that you understand, I believe, what Mr. Martin's cause. Well, I should speak to my own defense. You understand why I was out there. You understand my cause. I'm not asking you to vote Occupy. I just want you to understand that I do have a political protest, and it's just important you understand there is a coherent message. I think that is the essence of the First Amendment component in the affirmative defense. And if you remember what I said at the very end of my direct testimony about Officer Mitchell, I have no desire whatsoever to end Nate Mitchell's career. But in the back of my head, when I'm listening to them testify, if CAP hasn't broken up a protest, they've never broken up a protest, I'm just thinking, March 29th, 2012, and what Cameron told me on video, you need a permit to protest. Okay, so reasonableness, that's what the crux of the affirmative defense is, a reasonable time, place, and manner. The law does not have a provision that if the government offers a reasonable alternative, then a reasonable protest becomes illegal. And it's not a matter of breaking the law. This is the law. It's written right in there. This is the law, the affirmative defense. That's the law. Way I read that law, the government could offer 100 different reasonable alternatives. The only question is whether the citizens' actions, the specific actions chosen by the citizens in question, were they done in a reasonable time, place, and manner. I think they were. See, I'm trying to resurrect a political opposition that didn't go too well 2 years ago. A lot of mistakes were made, and I made quite a few of them. I was in a position of leadership in Occupy, and I blew it. So I'm trying to learn from my mistakes and come back. We're going to have a led opposition, not a leaderless opposition. We're going to have a clear alternative to, we're not just against the establishment. There's a clear alternative. There's a clear plan to achieve a revolution, this idea of occupying Alaska, concentrating ourselves geographically. Again, I understand this is somewhat extreme, but that is my message, and it is a legitimate First Amendment political message. It's not enough. We have to be reasonable. The law requires us to be reasonable, and that's fine. Reasonable is good, but it's also got to be effective. For me, as a political dissident, it's got to be effective too. And I've tried just showing up at the park at 2 o'clock in the afternoon, sending a press release, having a rally, giving a speech, going away, coming back the next week, and the next week, and the next week. Just doesn't work. It's not effective. What we have found, what my political opposition has found, is that this act of occupying the park, that's what's effective. That's what produces the attention we need to communicate our message through the media. We need a big demonstration. A little one doesn't do us any good. You heard Mr. Rada testify. It was growing. It was starting to become bigger. That's what I need it to be. And I can't do that in one day. I need more time so that it grows and it becomes bigger, and then the media has to really start paying attention to it, and we start getting it back on TV, and then I can just communicate this message to my supporters. Essentially, I feel that the municipality is trying to establish a precedent here to outlaw overnight political demonstrations. They can chop it up into pieces and say, well, if at this exact moment at 11:10 p.m. on Friday night, May 17th, 2012, you were not engaged in political demonstration. It's a little bit like if you're a diplomat and you go out to lunch, do you lose your diplomatic immunity because you went to lunch? You're not actually engaged in diplomacy at that moment. That's kind of how I feel it is. And if you can just find some little moment in this whole demonstration when right there you weren't actually engaged in First Amendment speech right at that moment, I think that's a pretty pretty restrictive, a very stifling environment for free speech if that precedent is allowed to be established in this municipality. The alternative they want to offer is that we approximate a multi-day demonstration by a string of single-day demonstrations. You set it up in the morning, you take it down at night. You set it up in the morning, and we've heard so much talk about the signage. The signage is important, and it's a fair amount of effort to, I mean, not a huge amount, but yeah, it's 10, 15 minutes of work to set them all up, and then another 10, 15 minutes, take them all down and bundle them up. Every day, set them up, take them down, set them up, take them down, set them up, take them down, set them up, take them down. This is the way to break up a political demonstration. So, in summation, I believe that, let's see, did I miss a point here? Just a second. Okay, yeah, in summation, I believe that a peaceful 24-hour sit-in in a public park diagonally across from City Hall is a reasonable time, place, and manner to conduct a political opposition. And finally, what I would just ask, just one final request, and that is just I wish to pray over this court. Ask you, Almighty God, to pour out your Holy Spirit upon this courtroom, to bless Judge Gregory Motika, and I ask you to bless John and Katharina, Mark, Chris, Linda, and George. Guide them, Father, to a just and honorable verdict. I ask this in Jesus' name. Amen. And thank you.
Did they do it? Did they show you? Did they meet their individual burdens of showing you that each of them met the burden of proof? It's not diplomatic immunity. They don't have any status as a protester. They spent a lot of time, each of them, possible exception of Ms. Thompson, trying to demonstrate to you that just by being John Martin, I'm protesting just by being me. I've established myself as just always being in a state of protest because I'm me. Here I am, John Martin, famous protester. No, that's not how the law works. The law doesn't say, were you legitimately engaged in First Amendment, expression of your First Amendment, or were you a known protester? That's not what the law says. You have to go by the law. Not by John's law, not by Margie's law, and certainly not by Brent's law, but by our law. Our law says you don't get to be clothed in protest. You don't get to be in protest all the time. You're not a diplomat. You don't have diplomatic immunity. What they're asking from you is make us immune to the laws of this city. Make it where we don't have to follow the same rules that you have to follow. Mr. Rada, the park rules don't apply to John Martin. He's a protester. That hasn't worked before. You heard him talk about Campbell Creek. You heard about him sleeping on the deck. That didn't work out for him. You're not protesting when you're asleep, okay, just because you're John Martin. And it's not going to work this time because you don't just get to clothe yourself in protesters' clothes and then always, whether you're in the bush peeing, whether you're on a beer run, or whether you're sitting back enjoying a cold brewski, you're protesting. That's not how the law works. But it is strategy. It is strategy because these people are strategic. They're not dumb. They're not stupid. They're not ignorant. They're strategic. And what you heard over the course of their testimony was you heard that, let's start with Martin. He wants what he wants, okay? You're going to see this exhibit. Admitted over our objection, that's fine. He wrote down on a piece of paper what he wants. He wants his own homeless camp. He has declared himself to be and crowned himself to be king of the homeless in Anchorage. Who says that John Martin speaks for all homeless in Anchorage? Who made him king of the homeless? John Martin did. What if there are some homeless people in Anchorage who, instead of going and living on a gravel lot with John Martin in a tent, want a home? What about those people? Because if you picture John Martin's homeless camp that he talked to you about, what he's saying is, I've decided it's okay to live outside. And I think everybody who's homeless in Anchorage should live outside with me. I think you, the city, should give me a piece of property so I can run this camp. And I am going to take Town Square Park hostage until you meet my demands. I am going to move in. I'm going to occupy, if that's what Mr. Bacala wants to call it. But I am going to keep pushing and pushing and pushing until I get what I want. What was the last statement that he gave when he got up from his seat here? He said, vote in favor of our homeless camp. I challenge you. Comb these instructions. Find the place where Judge Motika says you can vote in favor of John Martin's homeless camp. Is this trial about getting John Martin his homeless camp? No. This trial is about whether or not the laws that apply to you, that apply to Mr. Burr, apply to John Martin. Right? Because any of us would be held to the burden of our laws. That's the agreement when we live in a civilized society. We follow the law. They're saying, don't make us follow the law. We're special. We're protesters. You're not going to find a place in here to vote for John Martin's homeless camp. If you find that they met their burden of proof and then they met their affirmative defense and they're not guilty of trespass because they're John Martin, because they're Margie Thompson, because they're Brent Bacala, then all you're going to do is find them not guilty of trespass. That's it. You're not going to find, there's not going to be any fallout where all of a sudden we, the city, say, okay, well, I guess that means we have to give John Martin his homeless camp. Because you know what? There's more people in this world than him. And there's more people in this city than him. So the strategy of all three of these defendants has been to use and apply the law when it's to their advantage. So they wanted to talk a lot about, to the officers, remember, do you know the law? Are you following the law? But ignore or defy the law when it's not to their advantage. Let's talk for a minute about the flag that Mr. Bacala has wrapped himself in, right? First Amendment, this is the most important thing to him, right? Freedom of speech, freedom of religion. What is Mr. Bacala's intent? What does he want to do? He's told you, he's admitted exhibits that if you care to go and read them, you can. His intent is to get people from outside of Anchorage to come up here and take over our parks until what? Until we put leaders in that enforce the Christian religion as our law. Is that freedom of religion? What about the people in Anchorage who aren't Christians? Well, they're going to have to live under Mr. Bacala's Christian government, right? Isn't that the very foundation of our country? That we don't live under a Christian government? Or we don't live under a Muslim government? That we don't live under a Jewish rule? Or any other kind of religious rule? So, can you see how that is? Oh, the First Amendment is great as long as it enables me to talk about how I get to impose my religion on the rest of you. And once I get to that point, then it'll be a point where you're all going to be Christians whether you like it or not, right? No matter what the First Amendment says. So the First Amendment is good when it's to my advantage, and then it's out the window when it comes to my ultimate goal. Number 2 strategy, milk the resources. Spend as much of Mr. Rada's time as you can. Spend as much of the CAP team's time as you can. Spend as much of the Department of Law's time as you can. Get them to say things. Get them to do things. Get them to respond to me. You know? But the ultimate goal for Mr. Martin, open this homeless camp, you give him an inch, it takes a mile. 10,000 miles. Because nothing is going to satisfy him except being crowned king of the homeless and being given his own homeless kingdom. Push until you hit a wall. Keep pushing. Act like you're cooperating. Oh yes, Mr. Rada, we understand the rules of the park. I don't know if you remember when John Rada testified, but I was just struck. He's such a nice man, you know? And he spent so much of his time giving to these people. And he thought he had an understanding. And the only way I can describe what he said on the stand when I said, well, what did you think when you looked out there and you saw him set up in your town square park right at the time when you needed to be in there, you know, not having people tying things to trees and living in the park? And he said, I was amazed. But really, he was betrayed. That was betrayal because he had worked with these people. He thought he had an understanding. And they let everybody think, we understand. Sure, we understand. Oh, we want to play by the rules. Oh, they came up and told you. Oh, we want to follow the law. You know, it's just that the law says we can do whatever we want. That's not true. You're going to get the law. They can't do whatever they want. And then, how about the turning? You know, the turning. Oh, Mr. Rod is such a nice man. He's such a professional man. I'm glad you know him, Mr. McBride, because we think highly of him, you know. But then there's this evil city, right? This evil city. This Mayor Dan Sullivan, who are out to squelch their particular message. This isn't about their message. This trial is about their conduct. Okay? Let's keep the trial on what it's about. Whatever their message is, whether you think it's good, whether you think it's bad, great. You are not going to vote for Mr. Martin to get his way or Mr. Bacala to get his way. You're going to be voting on their conduct, and you're going to be voting on whether or not it's reasonable for the city to have some restriction on this activity. It's constitutional, I guarantee you. Is it reasonable for the city to say to people, everybody follow these rules, that way we can know, you know, the parks are safe at night, people aren't in danger, there's lots of reasons. They want to tell you it's reasonable. They want to tell you they didn't do anything bad. How many park rules did they break? Camping. That's a rule. Can only camp in Centennial Park with a permit. Is that reasonable? Yeah. Otherwise, what? Everybody be camping in all the parks, right? You guys have been out, been in Alaska, you've been camping, you see some people are good campers, some people are bad campers, right? So leave no trace, you know, some people do that, some people don't do that. Do they trash the park? Oh yeah. You saw the bags of trash, littering. Do they pee in the park? Yeah. You know, camp in the park, drink in the park. That's a rule. Right? Mr. Martin is so smug on that tape. You know, you see this man who sits here, all nice, and talks all soft and reasonable. On the tape, he's to the officers, I'll beat this in trial. I'll beat this. I know the law better than you. I know a lot more than you do about what you're doing here. He's smug, and he basically says to the officers with his Budweiser, cheers, mate. Glug, 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 glug. Drinking in the park is against the rules. Does he care? No. Why? He's John Martin. The rules don't apply to John Martin. He's the most ardent protester ever. And they're living in the park. And they're basically saying to you, I mean, the bottom line is, well, I'll get to the bottom line in a minute. First of all, I want to talk a little bit about Plaintiffs 13. I wanted you to see that. Do you remember that? That's Mr. Bacala. That's Mr. Bacala's video. You remember Mr. Bacala's video? Police Raid Christian Revolution. Okay, so you saw the tape. Was that a police raid of a Christian revolution? First of all, other than the scripture on the side, what was revolutionary about what they were doing? Okay? Second of all, on the tape he showed you, he had erased the little part where he went on a beer run. Why would he do that? That's strategy, number one, and that's tactical. It might make him look bad if he was on a beer run. It's better if everybody just thinks he was just out and about, downtown somewhere, when the police raided the Christian Revolution. He came up here and said to you, I used the word raid. Is it a raid when the police walk up and say, "Hi, Mr. Martin, how you doing tonight?" "Good, good. Park's closed. Time to get out. We'll help ya. You need help." And then, if you recall, in some of their testimony, they brought up SWAT teams. Where'd you see a SWAT team? This is the CAP team. This is the Community Action Policing Team. These are the nicest police officers you will ever meet. And having prosecuted since 1989, I can tell you that for a fact. These are nice police officers. Usually, when you say to a police officer, "Well, I'm not going to do that, let's debate the law." Remember when Mr. Martin said that? Police officers don't take that well, okay? They're out there to control situations. They're out there to make moves. They don't say, she said, "I'm not going to debate it with you, Mr. Martin, just let me tell you what's going to happen here." But nobody was mean to him. Nobody was rude to him. If you watch Plaintiff's Exhibit 13 without having sat through this trial, what would you think happened out there? You would think the police raided a Christian revolution. There was just enough of a clip, right? And then remember, there was all that screaming and ow, ow, ow. And then at the end, John standing there with his bruises for everyone to see. Share it on Facebook. Remember, share it on Facebook. What would you think happened? You would have thought he had been beaten up by the police, right? That's what Mr. Bacala wanted everybody who watched that video to think. That, ladies and gentlemen, is tactical deception. Take something, clip it up, put it together cleverly, sew some bruises. Where'd John get those bruises? He got those bruises from these officers. Why? Who was responsible for the bruises on John Martin's arm? John Martin. Because John Martin wouldn't have had those bruises on his arm if he had gotten up like a regular person and walked and put himself in the car. So, remember, milking resources? Let's just make it as hard on the police as possible. Let's make them drag me, Not because I don't recognize their authority, not because I don't recognize I'm going in that car, but just make it as hard for everybody as humanly possible. So here he comes all nicey nice at trial. I'm such an easygoing, reasonable man. That's not reasonable. It's not reasonable to make officers carry a grown man to the car, to force him to lift his dead weight such that they cause bruises on his arms, and then get up. Do you remember when John Martin testified? And I asked him about that blog, and he was like, "What blog? I've never seen that blog." He posed for that blog. I mean, you think the pictures with him without the shirt standing by the newspaper so we could see what day it was weren't posing? I mean, they talk in their opening about you're going to get people in this magic chair and they're going to lie to you. Yeah, there was someone in that magic chair that lied to you, and his name is John Martin, because he had seen that blog. That was part of his operation. He had posed for pictures for Britt to put up in his tactical deception to make it look like something that was happening that was not. To make it for people like their last witness to come in and say, "I'm just tired of these assaults on protesters." This was no assault on protesters. And finally, I want you to think about Town Square Park. Because it's being used. It's being used here. And you got the bottom line from them, If the jury finds us not guilty and the city doesn't do what we want, we're going back in. And if Mr. Bacala has his way, as he said, he'll build it. He'll talk some friends into coming. We'll get a lot of people there. We'll take over that park, and we'll take it over until we get what we want. That's not reasonable. That's not fair. It's not fair to you and me. It's not fair to Mr. Rada and his crew. It's not fair to the people who pay taxes to this city to maintain that space so that everyone can enjoy it. It's not fair for any of us to watch our park being taken over by people who have a specific agenda and who are saying, "I am taking this park hostage until you do what I want." There is nothing that is further from democracy than that. So Don't let them wrap the flag around themselves and hide in the cloak of democracy, when really what they're doing is trying to force us to give them their way. They did not prove this defense to you. This was not protesting. They were on a break from their protest. They don't get the cloak of protesting at all times just by virtue of being them. Margie didn't prove to you that she was doing anything except hanging out with her boyfriend and drinking a beer. Brent was on a beer run. John was on a break. If you're gonna get excused from the law, make them work for it. This is the laziest protest on the face of the planet. Make them work for it. If the officers had walked up and they were out chanting in a circle, chances are good they would have called their sergeant and said, what do we do? They're protesting. They weren't doing that. And they don't get to just have this ollie oxen free protesting. Whatever I do, I'm protesting, because it starts with Town Square Park. Where does it end? None of the laws apply to them because of who they are and what they want. Nothing further from democracy than that. Imposing the will of the few on the benefits to the many. Please protect our parks. They didn't prove their case. I proved mine. The only vote's guilty on all three defendants. Thanks very much.
Mr. Burke, can I ask you to pull that easel down? All right, ladies and gentlemen, the evidence has been presented to you, and you have heard the arguments of counsel and the parties. I will now give you the instructions concerning the law to be applied to the case. The law applicable in this case is contained in these written instructions, and it is your duty to follow them. You must consider these instructions as a whole, not picking out one instruction and disregarding others. Although you should pay close attention as we go through all the instructions, you will have these instructions with you in the jury room. It is your duty to determine the facts from the evidence produced in open court. You are then to apply the law to the facts and decide the case. No ruling or comment I have made during trial was intended to tell you how I think you should determine the facts or decide the case. The evidence which you are to consider consists of the testimony of the witnesses and any exhibits admitted into evidence. The production of evidence is governed by rules of law. It has been my duty as judge to rule on the admissibility of evidence. You must not concern yourselves with the reasons for these rulings. You cannot consider testimony or exhibits to which an objection was sustained, or testimony or exhibits which were ordered stricken. In determining whether any proposition has been proved, you should consider all the evidence bearing on the question without regard to which party produced it. While determining the facts in this case, you have the right to consider all the evidence in light of your own observation and experience in the affairs of life. The charging documents in this case reads essentially as follows. Count 1, that on or about the 17th day of May 2013 at or near Town Square Park, Anchorage, Alaska, the defendants John Martin, Brent Bacala, and Margie Thompson did knowingly enter or remain on public premises or property or in a public vehicle where the premises, property, or vehicle was not open to the public, or after they had been requested to leave by someone with apparent authority to do so, which is in violation of Anchorage Municipal Code 84510A3. To the charge, the defendants have entered pleas of not guilty, which places upon the municipality the burden of proving each and every allegation of the charge to the satisfaction of the jury beyond a reasonable doubt. The charging document in this case is a mere accusation against the defendants. It is not evidence of guilt of the defendants, and you should not permit yourself to be influenced to any extent, however slight, against the defendants for the filing of the charging document. In order to establish the crime of trespass under the Anchorage Municipal Code, it is necessary for the municipality to prove beyond a reasonable doubt the following elements. First, that a defendant knowingly entered or remained on public premises, property, or in a public vehicle, and secondly, they did so at a time when the public premises, property, or vehicle was no longer open to the public, or after they had been asked to leave by someone with apparent authority to do so. If you find that the municipality has proved each element of this offense beyond a reasonable doubt, then you must find the defendant guilty. If, however, you find that the municipality has not proved each element of this offense beyond a reasonable doubt, then you must find the defendant not guilty. To return a verdict of guilty or not guilty, each of you must agree with that verdict. A person acts intentionally with respect to a result when the person's conscious objective is to cause that result. A person may act intentionally with respect to causing a particular result, even though causing that result was not the person's only objective. A person acts knowingly with respect to conduct or to a circumstance described by a provision of law defining an offense, when the person is aware that the conduct is of that nature or that the circumstance exists. When knowledge of the existence of a particular fact is an element of the offense, that knowledge is established if a person is aware of a substantial probability of its existence, unless the person actually believes it does not exist. Of course, if a person acts intentionally, then the person also acts knowingly. It is an affirmative defense to the crime of trespass under Anchorage Municipal Code Section 845-110A3 if, at the time of their trespass, a defendant was engaged in the legitimate expression of First Amendment freedoms and the expression did not occur in an unreasonable time, place, or manner. As I have explained to you, the state or the city must prove the elements of the offense beyond a reasonable doubt. In instruction number 10, I will explain to you what it means to prove something beyond a reasonable doubt. But some of the questions in this case must be decided according to a different standard, which is known as a preponderance of the evidence standard. Something is proved by a preponderance of evidence when the evidence persuades you that it is more likely true than not true. When I specifically instruct you to decide whether something is more likely true than not true, you must apply this standard rather than the reasonable doubt standard. If you conclude that the municipality has proved all the elements of the offense of trespass beyond a reasonable doubt, then you must decide whether the defendant is not guilty because he or she is entitled to the affirmative defense I have just described in instruction number 7. For you to find that a defendant is not guilty in this case, you must find the defendant has proved that the following statements are more likely true than not true. 1. That at the time of his or her trespass, a defendant was engaged in the legitimate expression of First Amendment freedoms, and 2. The expression did not occur in an unreasonable time, place, or manner. In order to be entitled to this defense, a defendant must prove both elements by a preponderance of the evidence. That is, if you find that the statements 1 and 2 that I've just read you are both more likely true than not true, then you must return a verdict of not guilty for this offense. If you find that only one of the two elements has been met by a defendant, then they are not entitled to this defense. The distinguishing features of a criminal trial are what are known in the language of the law as the presumption of innocence and the burden of proof beyond a reasonable doubt. The law presumes a defendant to be innocent of crime. Thus, a defendant, although accused, begins the trial with a clean slate, with no evidence favoring conviction. The presumption of innocence alone is sufficient to acquit a defendant unless you are satisfied beyond the reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. This last mentioned requirement, that you be satisfied beyond the reasonable doubt of the defendant's guilt, is what is called the burden of proof. It is not required that the prosecution prove guilt beyond all possible doubt, for it is rarely possible to prove anything to an absolute certainty. Rather, the test is one of reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense. Proof beyond a reasonable doubt must be proof of such a convincing character that, after consideration, you would be willing to rely and act upon it without hesitation in your important affairs. A defendant is never to be convicted on mere suspicion or conjecture. The burden of proving the defendant guilty beyond a reasonable doubt always rests upon the prosecution. This burden never shifts throughout the trial, for the law never imposes upon a defendant in a criminal case the burden or duty of calling any witnesses or producing any evidence. A defendant has the absolute right not to testify, and you could not draw any inference against the defendant for not testifying. Thus, a reasonable doubt may arise not only from the evidence produced, but also from the lack of evidence. Since the burden is upon the prosecution to prove every essential element of the crime charged beyond a reasonable doubt, a defendant has the right to rely upon the failure of the prosecution to establish such proof. A defendant may also rely upon evidence brought out on cross-examination of witnesses for the prosecution. Every person who testifies under oath is a witness. You as jurors are the sole judges of the credibility of the witnesses. In deciding whether to believe a witness or how much weight to give to the witness's testimony, you may consider anything that reasonably helps you to evaluate the testimony. Among the things you should consider are the following: the witness's attitude, behavior, and appearance on the stand, and the way the witness testifies. the witness's age, intelligence, and experience, the witness's opportunity and ability to see or hear the things the witness testifies about, the accuracy of the witness's memory, any motive of the witness not to tell the truth, any interest that the witness has in the outcome of the case, any bias of the witness, any opinion or reputation evidence about the witness's truthfulness, any prior criminal convictions of the witness related to honesty, the consistency of the witness's testimony and whether it is supported or contradicted by other evidence. You should bear in mind that inconsistencies and contradictions in a witness's testimony or between a witness's testimony and that of others do not necessarily mean that you should disbelieve the witness. It is not uncommon for people to forget or remember things incorrectly, and this may explain some inconsistencies and contradictions. It is not uncommon for two honest people to witness the same event and see or hear things differently. It may be helpful when you evaluate inconsistencies and contradictions to consider whether they relate to important or unimportant facts. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but are not required to do so. You may believe all, part, or none of the testimony of any witness. You need not believe a witness even if the witness's testimony is not contradicted. However, you should act reasonably in deciding whether you believe a witness and how much weight to give to the witness's testimony. A fact may be proved by direct evidence, by circumstantial evidence, or both. Direct evidence is given when a witness testifies about an event which the witness personally saw or heard. Circumstantial evidence is given when a witness did not personally see or hear an event but saw or heard something which, standing alone or taken together with other evidence, may lead a juror to conclude that the event occurred. Both types of evidence are admissible and may be considered by you. Neither is entitled to any greater weight than the other. A person's mental state may be shown by circumstantial evidence. It can rarely be established by any other means. Witnesses can see and hear and thus be able to give direct evidence of what a person does or does not do. But no one can see or hear the mental state that a person had at the time the person acted or did not act. Yet what a person does or does not do may indicate that person's mental state. You may consider any statements made and acts done or not done by the person and all other facts and circumstances in evidence when determining that person's mental state. The defendants testified in this case. You should judge the testimony of the defendants in the same manner as you judge the testimony of any other witness. At the close of the case to you, there were summations. The summations of the parties based upon study and thought may be and usually are distinctly helpful. However, you should remember that summations are not evidence and cannot be considered as such. It is your duty to give careful attention to the arguments if they are based upon the evidence and upon the laws given to you by me in these instructions. But the summations, if they depart from the facts or from the law, should be disregarded. The parties, although maybe acting in good faith, may be mistaken in their recollection given during the trial. You are the ones to determine what evidence was given in the case as well as what conclusions of fact should be drawn therefrom. If the court has repeated any rule, direction, or idea or stated the same in varying ways, no emphasis was intended, and you must not draw any inference therefrom. You are not to single out any single sentence or particular individual point or instruction and ignore the others. You are to consider all the instructions as a whole and are to regard each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. The attitude and conduct of the jurors at the beginning of their deliberations are matters of considerable importance. It is rarely productive for a juror at the outset to make an emphatic expression of his or her opinion on the case and state how he or she intends to vote. When this is done at the beginning of deliberations, the juror's sense of pride may be aroused and the juror may hesitate to change his or her position even if shown that it is wrong. Remember, you are not partisans or advocates in this matter, but are judges. As jurors, you have the duty to consult with one another and deliberate with a view to reaching an agreement, if that can be done without violence to individual judgment. Each juror must decide the case independently, but only after an impartial consideration of the evidence with the other jurors. In the course of deliberations, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced that it is erroneous. But no juror should surrender an honest conviction as to the weight or effect of evidence solely because of the opinion of other jurors or for the mere purpose of returning a verdict. In your deliberations, do not discuss or consider the subject of possible penalty or punishment. That subject must not in any way affect your verdict. During your deliberations, a bailiff will be appointed to keep you together and prevent conversations between you and any other persons. The bailiff will provide you with such requirements as meals and will make phone calls to your families when necessary to let them know your schedule. The bailiff cannot answer any questions about this case or provide you with any information, books, or materials, as I have strictly forbidden this. The bailiff, as well as all the persons, is forbidden to communicate in any way or manner with any member of the jury on any subject touching on the merits of the case. Bear in mind also, you are never to reveal to any person, not even to the bailiff or to me, how the jury stands numerically or otherwise on the question of guilt or innocence of the accused, until authorized by the court. Any violation or perceived violation by a fellow juror of any item which I have cautioned you is to be reported by you as a body or individually to me. If it becomes necessary during your deliberations to communicate with me, you may send a note by the bailiff signed by your foreperson or by one or more members of the jury. No member of the jury should ever communicate with me by any means other than a signed writing. The writing should contain the date and time of the communication. I will not communicate with any member of the jury other than in writing or here in open court. Judges frequently receive written questions about the case by jurors during their deliberations. Although I cannot always answer those questions, I am free to tell you that if you desire to be informed on any point of law arising in the case, you may write which point of law you wish to be instructed about on a piece of paper, hand it to the bailiff, and I will convene the court for consideration of the questions. Similarly, if there is a disagreement among you as to the testimony of a particular witness or witnesses, you may write which witness's testimony you wish to have played back, and we will listen to it here in open court. A brief delay may occur prior to a response to your question or request, since I must first convene the parties, my clerk, and myself for consideration of the question. I do not tell you this to discourage your writing a question, but so that you will understand any delay that will occur. You are accepted as jurors in this case in reliance upon your answers to the questions concerning your qualifications. You are just as much bound by those answers now and until you are finally discharged from further consideration of this case as you were then. The oath taken by you obligates you to try this case well and truly and render a true verdict according to the law and the evidence. Both the city and the defendants have the right to expect that you will conscientiously consider and weigh the evidence and apply the law of the case, and that you will reach a just verdict. Upon your return to the jury room, you will select one of your number, man or woman, to act as a foreperson. The foreperson is to preside over your deliberations. You will take with you to the jury room the exhibits and these written instructions, together with the 3 verdict forms, which are self-explanatory. Each of your verdicts must be unanimous, that is, you must agree with each verdict. And this is where I will depart a little bit from our jury instructions. As I told you earlier today, I have to leave this building probably sometime around 3:30. I will not be coming back during normal business hours. Normally what would happen would be I would excuse our alternate juror at this point. I would let the jury of 6 go and deliberate, and if you were able to reach a verdict before 4:30, you'd come back and give it. If you hadn't been able to reach a verdict, you'd have a choice. You'd be able to stay here past 4:30 and deliberate as a group under the watchful eyes of our bailiff. And if you reached a verdict, then you would be able to come seal it in an envelope, and then you would be able to come back tomorrow and deliver it in open court. If you decided to go past 4:30 and continue to deliberate and did not reach a verdict, you decided that, well, we've been going at this for 7 hours and it's time we go home, then you would just disband, go home, and then come back tomorrow morning and start. What my absence starting at 3:30 is going to mean is that if you're not able to reach a verdict by 3 o'clock or something like that, which is only 50 minutes away, you're going to have to come back anyway. And that's what I'm getting to. We have an alternate. The alternate can't deliberate with you, and if for some reason, if you want to start deliberating now, I'll excuse the alternate. But if then one of you got sick or something happened tomorrow, we would not have a full panel. So one of the alternatives I'm going to propose is that if you wish, I will simply excuse you today and let you go home, and then come back as a group of 7 tomorrow morning. And if everybody is healthy and present, then I would excuse our alternate. Does the panel want to start deliberating now? Because if you do deliberate, then you can go to 4:30 or even past 4:30, but you're still going to have to come back tomorrow. Do you wish to... Is that the group consensus then? Okay. Then what we will do is we will excuse you. Again, you're not to deliberate amongst yourselves until you're brought back tomorrow. Sir?
If we have some questions for you, do we bring them up tomorrow?
Yes.
Okay.
Why don't you be back in the jury room then tomorrow at 8:30? Again, we'll take your notes, we'll put them in the evidence locker and distribute them back to you tomorrow. So keep an open mind. Don't discuss the case amongst yourselves. Yes.
At 8:30, we just start.
At 8:30, you'll gather, and then I will excuse Ms. Kiefer, and then I will send you out to deliberate. So when you gather in the jury room, don't discuss the case. We'll get you back into court right at 8:30 as soon as we can. Excuse the alternate, and then you will start. Okay? Thank you very much. With the thanks to the court and the parties, you are excused for the day. Okay, couple of housekeeping matters. I'd like the parties to come up and make sure that all of your respective exhibits are accounted for here, because we're going to have to give them to the jury tomorrow. Second thing, the jury tomorrow may or may not ask for what's called playbacks, where they may go ahead and ask for certain parts of testimony to be played back. No new testimony comes in. We just simply find out what they want, we play it on the overhead, and they re-listen to it. Parties have the right to be present. You also have the right to waive your presence, because again, all you're going to be able to do is sit here while this is being played. I have to ask the parties, if they do want to have a playback, do you want to be present?
We waive.
No, to be present.
What did the prosecution do?
They waived.
They waived.
The jury has a question that we have the right to be here.
No. If the jury has a question, and we're getting an indication that they may have a question, we will all come back here. This is only, we want to hear the testimony of Mr. Rada again. And then we would pull up Mr. Rada's on the computer and replay it. So for questions, you're definitely going to be here, because I'm going to need to get input on both sides as to what my response should be to their question. But for purposes of just playing back testimony, do you wish to be notified if that happens tomorrow? It may not happen. I mean,
Yeah, we'll waive
okay,
for the situation.
for playbacks. Okay, third question, we need basically a way of contacting you tomorrow once they get out. I expect everybody to be back here at 8:30 so that we can see that we've got the full panel. I'll excuse the alternate, and then they'll start deliberation, and then you'll be free to go. Now, it sounds like they're going to have questions right off the bat, so probably a good idea. I'll raise that when I excuse them, you know, to basically go out, write your question, and then we'll deal with those questions, and then we'll send them out. And then at that point, I'll need telephone numbers so that I can notify you, hey, they've got another question or they have a verdict, and we'll call you and you'd come in. Are you still going to be remaining in the downtown area, I assume? You're not going to head out to someplace else?
We'll be close enough to make it back in short time.
Good.
And you can contact all of us through Brent's phone.
Okay, and Mr. Vakala, your phone number is?
My phone number is 443
443
618
618
8702.
8702.
Okay. So, we'll see everybody tomorrow at 8:30.
One question, could I get a copy of the piece of evidence that was entered that has to do with my request to the city for a camp?
I thought we did that already.
The only copy I saw, I returned to the court. If there was another copy.
Did you make-
I didn't.
Yeah, I made a copy, but then I think he used that as the exhibit.
Okay, then you, okay, I thought, oh, yeah, okay, you're right, you're right. Go ahead and make a copy then for Mr. Martin.
Okay.
Okay, we'll see everybody tomorrow.
Thank you, Judge.